The DFS case that both defendants participated in did not include the named victim in this case because he had a protective father with them. I know that there was going reports as far as the defendants with their child, but I would note that's their biological child. The child is differently situated.
Case number 2C348747-1, State of Nevada versus John Woodruff. Case number 3C348747-2, State of Nevada versus Destini Woodruff.
Morning, Robert Draskovich on behalf of Destini Woodruff, who is present at liberty.
Your Honor, good morning, Louis Schneider, on behalf of John Woodruff, who's present as well, Your Honor.
Good morning.
Good morning, Your Honor. Michelle Jobe, Bar number 10575 with the state.
Good morning. So I do have one GPA for Destini Woodruff. We have one for Mr. John Woodruff.
We do, Your Honor. Just want to make sure that this is the executed copy. I'm sorry, that's not it. This must be it. I thought we left one here, Your Honor, but maybe not. There was an error. Oh, this is correct. Accept. Approach, Judge. Sure. Thank you, Your Honor. Sorry, Judge.
That's okay. Okay, let's go case one and case one's Mr. Woodruff, case two, Ms. Woodruff. So what are the negotiations on Mr. Woodruff?
Your Honor, this morning the defendant, Mr. John Woodruff, is going to plead guilty to 2 counts of child abuse, neglect, or endangerment. 1 is a Category B felony. Count 1. Count 2 is a gross misdemeanor. The state agrees to make no recommendation at sentencing. The parties waive any defects in the pleading as to count 2. The deal is contingent on the co-defendant following through with negotiations to resolve the case. All remaining counts in the indictment shall be dismissed when the defendant is adjudged guilty and sentenced.
That's correct, Your Honor.
And Mr. Woodruff, is that also your understanding of your negotiations?
Yes, Your Honor.
Okay, what are the negotiations on Ms. Woodruff?
Your Honor, she's going to enter a plea to 1 count of child abuse and neglect. The state will be making no recommendation at the time of sentencing.
And hers is a Category B felony, right?
That's also contingent.
And Ms. Woodruff, is that also your understanding of the negotiations?
Yes, Your Honor.
Okay. So we'll go, I'll ask both of you essentially the same questions. Let's have Ms. Woodruff answer first, and Mr. Woodruff answer after her. What's your full name?
Destini Woodruff.
John Wesley Woodruff III.
Thank you both. So you know if those are not your true names, you must declare true names to me, or all proceedings in these cases will be under the names set forth in the amended indictments, which are Destini Woodruff, a.k.a. Destini Hover, and John Woodruff, a.k.a. John Wesley Woodruff III. Do you understand that?
Yes, Your Honor.
Yes, Your Honor.
How old are you?
I am 29.
32, Your Honor.
How far did you go in school?
Bachelor's.
High school diploma, sir.
Do you have any sort of learning disability?
No.
No, Your Honor.
Do you read, write, and understand the English language?
Yes.
Yes, Your Honor.
Have you been treated recently for any mental illness or addiction of any kind?
No, Your Honor.
Has anyone ever suggested that you should be treated for a mental health or emotional condition?
No, Your Honor.
No, Your Honor.
Are you currently under the influence of any drug, alcohol, or medication?
No, Your Honor.
No, Your Honor.
Do you understand what's happening this morning?
Yes, Your Honor.
Yes, Your Honor.
Do you feel comfortable going forward with the guilty plea agreement this morning?
Yes.
Yes, Your Honor.
Thank you both. Turning back to respective counsels, first Mr. Draskovich, have you observed any cognitive difficulties with Ms. Woodruff?
No, I'm not.
Thank you. Turning now to Mr. Schneider, have you observed any cognitive difficulties with Mr. Woodruff?
No, Your Honor.
Thank you both. Turning back to you two. Have you received a copy? Well, this will be a little different, so I'll ask Ms. Woodruff first and then Mr. Woodruff. So, Ms. Woodruff, have you received a copy of the amended indictment wherein you've been charged with child abuse, neglect, or endangerment, category B felony?
Yes.
And Mr. Woodruff, have you received a copy of your amended indictment wherein you've been charged with child abuse, neglect, or endangerment, category B felony, and child abuse, neglect, or endangerment, gross misdemeanor?
Yes, Your Honor.
Do you understand the charge contained in the information?
Yes.
Yes, Your Honor.
Have you discussed this case with your attorney?
Yes, Your Honor.
Yes.
Are you satisfied with the representation and advice given to you by your attorney?
Yes, Your Honor.
Yes.
As to the charge, and we'll go first with Ms. Woodruff, as to the charge contained in the amended indictment, child abuse, neglect, or endangerment, category B felony, how do you plead?
Guilty.
Thank you. Going to you, Mr. Woodruff, as to the charges contained in the amended indictment, child abuse, neglect, or endangerment, category B felony, and child abuse, neglect, or endangerment, gross misdemeanor, how do you plead?
Guilty.
Going back to the two of you, are you making this plea both freely and voluntarily?
Yes.
Yes, Your Honor.
Has your attorney or anyone else forced or threatened you or anyone close to you to get you to enter this plea?
No.
No.
Has your attorney or anyone else made you any promises other than what's in the guilty plea agreement to get you to enter this plea?
No.
I have before me your respective guilty plea agreements. Did you sign the guilty plea agreement?
Yes, Your Honor.
Yes, Your Honor.
Before you signed it, did you read it?
Yes, Your Honor.
Yes.
Before you signed it, did you discuss it with your attorney?
Yes, Your Honor.
Yes.
Do you understand everything contained in the guilty plea agreement?
Yes.
Yes.
Do you understand the constitutional rights you're giving up by entering the plea of guilty?
Yes.
Do you understand the appellate rights you're giving up by entering the plea of guilty?
Yes.
Yes.
Do you understand if you're not a United States citizen that entering a plea of guilty may have immigration consequences, including deportation?
Yes.
Yes.
Do you understand, we'll have to do these one at a time too, Ms. Woodruff, do you understand that the range of punishment is as follows? As a consequence of your plea of guilty, you may be in prison in Clark County. Probably something wrong here. She's pleading to category B felony, but it says 364 days CCDC.
I fixed it, Your Honor, and provided it to counsel.
And that was electronically filed this morning.
Okay.
May I approach, Your Honor?
Yeah,
It's not
sure.
the signed copy, but it has.
Okay.
Yes, she appeared in my office this morning and we filed.
Okay. Okay. So let me just double check that real quick.
Would actually ask that the GPA, Your Honor, had be stricken.
Yeah, that's so yeah, now I pulled up the one filed this morning. So the guilty plea agreement filed on October 3rd for Ms. Woodruff's stricken. We'll go on the guilty plea agreement filed on October 10th. Going back to you, Ms. Woodruff. You understand that the range of punishment is as follows. As a consequence of your plea of guilty, the court must sentence you to imprisonment in Nevada Department of Corrections for a minimum term of not less than 1 year, maximum term not more than 6 years, minimum term may not exceed 40% of the maximum term of imprisonment. Law does require you to pay administrative assessment fee and other fees. Also, if appropriate, you'd be ordered to make restitution to the victim, reimburse the state of Nevada for extradition expenses, if any. You also understand you're not eligible for probation pursuant to statute unless a psychologist licensed to practice in the state who's trained to conduct psychological evaluations, or a psychiatrist licensed to practice medicine in the state who's appropriately certified, trained to conduct such evaluations, certifies in a written report that to the court that you do not represent a high risk to reoffend. You also understand, except as otherwise provided by the statute, whether you see probation's in the discretion of your sentencing judge. Your attorney is responsible for obtaining the evaluation, providing it to the court and the deputy district attorney prior to sentencing. You must submit to DNA testing. Do you understand all of that?
Yes.
And let's stick with you a little bit just to make sure we're all on the same page going back. So now I have before me the guilty plea agreement filed earlier this morning, October 18. Did you sign that guilty plea agreement?
Yes.
Before you signed it, did you read it?
Yes.
Before you signed it, did you discuss it with your attorney? You understand everything contained in the guilty plea agreement filed this morning?
Yes, Your Honor.
Do you understand the constitutional rights you're giving up by entering the plea of guilty?
Yes, Your Honor.
Do you understand the appellate rights you're giving up by entering the plea of guilty?
Yes.
Okay. Let's go to Mr. Woodruff now. Mr. Woodruff, you understand that the ranges of punishment are as follows. On count 1, as a consequence of your plea of guilty, the court must sentence you to imprisonment in Nevada Department of Corrections for a minimum term not less than 1 year, maximum term not more than 6 years, minimum term may not exceed 40% of the maximum. On count 2, you may be imprisoned in Clark County Detention Center for a period not more than 364 days and may be fined up to $2,000. The law does require you to pay administrative assessment fee and other fees. Also, if appropriate, you'll be ordered to make restitution to the victim, reimburse the state of Nevada for extradition expenses, if any. As to both count 1 and count 2, you are not eligible for probation pursuant to statute unless a psychologist licensed to practice in the state is trained to conduct psychological evaluations, or a psychiatrist licensed to practice medicine in the state is appropriately certified and trained, certifies in a written report to the court that you do not represent a high risk to reoffend. Except otherwise, the question of whether you receive probation is in the discretion of your sentencing judge. Also, your attorney is responsible for obtaining this evaluation, providing it to the court and the deputy district attorney prior to your sentencing. And finally, you must submit to DNA testing. Do you understand all that?
Yes, Your Honor.
Okay, going back to both of you now again. You understand that sentencing is up to your sentencing judge, including whether any counts will run consecutive or concurrent?
Yes.
Yes, Your Honor.
You understand you're not guaranteed to have me as your sentencing judge. It could be any constitutionally seated district court judge or senior judge assigned by the Supreme Court?
Yes, Your Honor.
Yes, Your Honor.
You understand no one is in a position to promise you probation, leniency, or special treatment?
Yes, Your Honor.
Yes, Your Honor.
Going back, we'll need to do these one at a time as well. On Miss Woodruff, there's not a copy of the amended indictment filed with the GPA. I don't know if that presents any issue.
We'd waive any issues substantively or procedurally. The state can file the amended indictment.
Double check.
It's the same as what we previously filed with the court. There was some language contained.
Oh, looks like it was filed on September 29, but not attached to the GPA. So, defendant weighs any substantive or procedural issues with that?
Yes, Your Honor.
Okay. So, Ms. Woodruff, sorry. Going back to you, in the amended indictment, says that you, Destini Woodruff, committed that within the County of Clark, State of Nevada, on or between October 1, 2018, May 15, 2020. You did as follows. You did willfully and lawfully feloniously cause a child under the age of 18 years, to wit, BH, being approximately 6 years of age, to suffer unjustifiable physical pain or mental suffering as a result of abuse or neglect, to wit, physical injury of a non-accidental nature and or negligent treatment or maltreatment of a child, and or cause BH to be placed in a situation where he or she might have suffered unjustifiable physical pain or mental suffering as a result of abuse or neglect, to wit, physical injury of a non-accidental nature, negligent treatment or maltreatment of a child, by punishing BH, a boy, by purchasing girls' clothing and or and making BH wear said clothing to school and or to McDonald's, wearing girls' clothing and or by beating BH and or striking the bare bottom legs or back of BH with your hands and or belt or an unknown object, and or by Defendant John Woodruff grabbing BH by the neck and or throat and lifting him off the ground, you being criminally liable under one or more of the following principles of criminal liability, to wit, by directly committing the crime and or to aiding or abetting John Woodruff in the commission of this crime with the intent to commit this crime by providing counsel and or encouragement to John Woodruff, you and John Woodruff acting in concert and or pursuant to conspiracy to commit this crime. Is that indeed what happened and what you did?
Yes.
And is that why you're pleading guilty this morning?
Yes, Your Honor.
Okay. Turning back to you, Mr. Woodruff, in the amended indictment, it says that you, John Woodruff, committed and within the County Clark State of Nevada honor between October 1, 2018 and May 15, 2020 as follows. On count 1, you did honor about May 9, 2020, willfully, lawfully, feloniously cause a child under the age of 18 years, to wit, BH being approximately 6 years of age, to suffer unjustifiable physical or mental suffering as a result of abuse or neglect, to wit, a physical injury of non-accidental nature and or negligent treatment or maltreatment of a child, and or cause BH to be placed in a situation where he or she might have suffered unjustifiable physical pain or mental suffering as a result of the abuse or neglect, to wit, physical injury of a non-accidental nature and or negligent treatment of the child by striking bare bottom legs and or back of BH with your hand, and or a belt and or an unknown object, and or by you grabbing BH by the neck and or throat and lifting him off the ground, you being criminally liable under one or more of the following principles of criminal liability, to wit, 1, by directly committing the crime, and or 2, by aiding or abetting Destini Woodruff in the commission of this crime with the intent that the crime be committed by providing counsel and or encouragement, you and Destini Woodruff acting in concert and or pursuant to conspiracy to commit this crime. Count 2, you did honor between October 2018 and April 30th, 2019, you did willfully and lawfully being responsible for the safety or welfare of a child under the 18 years of age, to wit, BH being approximately 6 years of age. You did permit or allow BH to suffer unjustifiable physical pain, mental suffering as a result of the abuse or neglect, to wit, negligent treatment or maltreatment of a child by punishing BH, a boy, by purchasing girls' clothing and or making BH wear said clothing to school and or to McDonald's, but wearing girls' clothing and or by beating BH, you being criminally liable under one or more of the following principles of criminal liability, to wit, 1, by directly committing the crime and or 2, by aiding or abetting Destini Woodruff in the commission of this crime with the intent that this crime be committed by providing counsel and or encouragement, you, Destini Woodruff, and you acting in concert throughout and or pursuant to conspiracy to commit this crime. Is that indeed what happened and what you did?
Yes, Your Honor.
And is that why you're pleading guilty this morning?
Yes, Your Honor.
Going back to the two of you, do either of you have any questions that you would like to ask either me or your respective attorneys before I accept this plea?
Your Honor.
No, Your Honor.
Thank you both. The court finds that Defendant Destini Woodruff and Defendant John Woodruff's respective pleas of guilty are freely and voluntarily made, and defendants respectively understand the nature of the offenses and consequences of their respective pleas, and therefore the court accepts their respective pleas of guilty. Matters referred to Department of Parole and Probation for pre-sentence investigation reports set for out-of-custody sentencing dates.
January 17th, 2023, 8:30 a.m.
And that's for both of you. You're both ordered to report to parole and probation immediately, no later than close of business tomorrow. We'll give you a sheet on how to do that. Anything else?
We have a motion, Your Honor.
We had a motion pending right now, provided the court, this is concerning Miss Woodruff. I realize that she may be statutorily precluded from proceeding in family court that preceded my representation of her in this case. I provide documentation that she did participate in a case plan. I'm just going to ask for the purposes of this case before Your Honor that you lift just the blanket no contact order and order her to have contact only as allowed by a district court judge. I believe it was Judge Gibson in family court. And that's our only request.
The only challenge with that, Your Honor, is, and the father's here to be heard as well on this, based on the rights under the Nevada Constitution. The challenge is the DFS case that both defendants participated in did not include the named victim in this case because he had a protective father when they did their case plan and all their courses, as evidenced by the information and the reports provided by counsel for Ms. Woodruff. That child was not part of what they did or part of the counseling or the therapeutic process. It's been 2.5 years since this child saw either defendant. The state's concern, based on what's been told to me by the father, is that there's trauma that this child has suffered, and just a carte blanche, feel free to have access, isn't what would be best for this child. And I would just point out a couple of things.
Well, hold on. Sorry. Okay, go ahead.
I did speak to the father before I filed the opposition, and he's requesting in here to also state his request that Destiny not be allowed to have contact. As I articulated in our opposition, the concern is if the court just lifts the no contact order, that Destiny will essentially be free to do what she wants, which would be traumatic for the victim. I note that in multiple letters provided to the court from Destiny's counsel, the Red Rock Psychological Health has laid out specific guidelines for reunification and for how it should work in order to protect the well-being of the child and the family. And so none of that has happened. None of that is in place. And so that's part of the basis of requesting that the no contact order continue. For specific reference purposes, I note in the June 17, 2021 letter from Red Rock, they note that both the perpetrator and any primary or secondary victims are expected to participate in therapy prior to the start of the reunification process. It should occur only after both the victim's therapist and perpetrator's therapist deem it appropriate. I would also note that in the letter from Red Rock on April 12th of 2021, both defendants continue to deny and denied throughout the course of their case that some of the allegations as it relates to the victim, which is very concerning to the state, that they continue to deny some of the things that were done to this child at the time of these events, and how that would impact any contact that they have with them. I know that there was glowing reports as far as the defendants with their child, but I would note that's their biological child. The child is differently situated with both defendants. As opposed to the child at issue in this case, who would be the stepchild to Mr. Woodruff. And so there are a number of concerns that the state still has with respect to the well-being of the child. So we would ask that Your Honor deny the motion, and then we would ask under the Nevada Constitution that Mr. Hoops be allowed to address the court regarding his wishes.
And in response to that, what's in the best interest of the child? Really, no contact with mom. That doesn't help the child. We're asking that this contact occur in a therapeutic setting. I think it's beyond dispute that that's in everyone's best interest. So, like I said, we're not asking a carte blanche access, but we're asking a therapeutic setting or a structured setting that begin this process. It's been 2.5 years this child's not had contact with the mother. Continue this blanket no contact order. Regardless of what occurred, we have a guilty plea before Your Honor, regardless of what dad wants. It's not good for a child. The leading causes for mental distress, and there's science on this, is a sense of abandonment. We're concerned about this child feeling this way. So we're not saying, hey, let's pick this child up and go to Disneyland this weekend. We're asking for there to be contact now established in a therapeutic and structured setting. I don't think that's an unreasonable request. And on that, we'll submit it.
Thank you both.
Mr. Hoops, address the court, please.
Well, I think what I'm going to do will be to continue this.
Okay.
And I'll tell you why. For better or worse, and it's not unusual, but it makes it hard for me. I have fairly limited motion and a fairly limited opposition. Both sides have referred to the different alleged facts or issues or things that as I sit here, am not familiar with. And so, and it is defendant's motion. And so, what I would suggest is supplemental brief by defendant, supplemental opposition by the state, and we coordinate a hearing date that works for both parties, including the father, the biological father, and hear further arguments at that time. Mr. Draskovich, anything on that?
We prefer not to wait until January 17th. Could we set something maybe middle of December? I'm assuming by that time she will have completed her danger evaluation. I think it's something the court should consider as well, in conjunction with our request.
Anything from the state?
Let me just ask the father what days of the
Okay.
request. Court's pleasure as far as day of the week is concerned. I would ask that it not be before December 9th.
Fine.
Okay.
I'm out of the country from December 20th through January 2nd.
Okay, so post 9 before the 20th, you said? Maybe we work backwards then. Let's do the 13th for the hearing, if that December 13th?
December 13th at 8:30?
Yeah.
I'll see you then. We'll provide supplemental briefing.
Your Honor,
Well,
just,
so the state will need to have an opportunity to pose whatever it is you file. So how soon do you want to, and it's fairly far out, so
December 1st, we'll have everything filed. Is that? I've made our request, I'm fairly transparent, in speaking with Jobe and what I've presented to the court today.
Is it possible to have it?
so file yours on the 22nd, I guess, of
Okay.
November.
That's fine.
And then date 2 weeks after that on the 6th, and that way I'll have both.
Your Honor, may we approach?
Sure. So, what are the dates again?
I believe it was 12/6 for the state's response.
Correct.
Then sentencing is when?
No. Sentencing is January 17th, 2023 at 8:30 a.m.
And both of you are to report to PNP by close of business tomorrow. Don't forget to file the GPA.
Thank you.
yes, Your Honor, I'll do it today.
Thank you, Your
Thank you,
Honor.
Your Honor.
Recall page 13.